assault on...
Sir, you need to leave right now. We've had multiple complaints about you just sitting around here making people uncomfortable.
I'm just reading. This is a public library. I'm sitting here quietly with my books and my laptop. I don't care what you're doing.
You need to leave now or you're going to be arrested.
The paper trembled in his hands, not from fear, but restraint. Under the glare of red and blue strobes, a black civil rights attorney stood on a public sidewalk, reading the law aloud as if it were a shield. The officer didn't listen. Radios hissed. A cruiser door opened. Somewhere behind a raised phone, a bystander pressed record. Minutes later, the footage would rupture careers, rewrite policy, and force a city to confront the cost of ignoring its own constitution. If stories of power, restraint, and consequence matter to you, if you believe the law lives or dies in ordinary moments, stay with this one. Watch closely. Listen between the words, because what unfolds here isn't just an arrest, it's a reckoning. The light was going thin when it began, the hour when offices exhale and the street relearns itself. Glass towers still held the day's warmth, and the sidewalk smelled faintly of hot concrete and coffee grounds. He stood near the curb, not in the way, not in a hurry. Jacket unbuttoned, briefcase set down with care. The phone in his hand glowed against the dusk as he read, steady and precise, the cadence of someone who had said these words before and would say them again, not loudly, not performatively, just enough to be heard. A patrol car rolled past once, then slowed on the return. Tires whispered. The cruiser settled into the curb with a soft mechanical sigh, lights clicking on without urgency. Red and blue washed the storefronts, turning reflections into warnings. The officer stepped out, posture squared by training, hand hovering near the radio. "What's going on here?" he asked, neutral on paper, edged in practice. "I'm reading," the man said, eyes still on the screen. On a public sidewalk. He didn't offer his name. He offered the law, citing the public forum doctrine, the part about time, place, and manner restrictions. The words landed cleanly, like facts should. A second unit arrived, then a supervisor, arriving not fast but decisively, as if the scene had called for him. The air tightened in layers. Radios hissed with distant calls. Someone across the street lifted a phone, then another. The bystander footage would later be described as steady, unembellished. At the time, it was just a rectangle of attention. "You're obstructing," the officer said, eyes flicking toward the camera. The word did work the moment it left his mouth. It implied motion where there was none, danger where there was calm. Training manuals teach command present, control the scene, assert authority early. The problem with doctrine is that it doesn't always recognize restraint when it sees it. "Obstructing what?" the man asked, finally looking up. His voice didn't rise. He quoted the statute again, careful with syllables. He asked for a supervisor, though one already stood there, arms crossed, listening with the patience of someone who believes time is on his side. The supervisor said nothing. Silence can be an instruction if you wear it right. A pause, the kind that stretches because everyone knows the next step and no one wants to own it. The officer shifted his weight. "Turn around," he said, short, clean, police style. A command designed to end a conversation. "I haven't committed a crime," the man replied. He didn't argue, he didn't plead. He read one more line, the part about retaliation for protected speech. The phone trembled now, not from fear, but from the effort of keeping the voice level while being disbelieved. The cuffs came out with a practiced economy. No rush, no visible anger. That's what would haunt people later, the calm. Steel touched skin. The click was soft, almost apologetic. A bystander inhaled sharply off camera. Someone whispered, "He's just reading." As they guided him toward the cruiser, he asked again for the basis of the arrest. The answer didn't come. The supervisor finally spoke, not to him but to the officer. "Do what you need to do." Policy language, distilled to its most dangerous form. The door opened. The interior light flicked on, revealing the scuffs and stains of 100 ordinary nights. As he ducked his head, he caught the camera's eye, not defiant, not broken, just present. The door closed. The sound was final in a way paperwork never is. The timestamp kept running. So did the law, somewhere beyond the glass and steel, waiting to be read again. The video didn't explode. It seeped, uploaded without a caption at first. It appeared the way truth often does now, quietly. Between dinner and late-night scrolling, a rectangle of light sliding into feeds already crowded with noise. The bystander's hand was steady. No commentary, no edits. Just the sidewalk, the lights, the voice reading law into a microphone that didn't exist. Within hours, the clip found its title elsewhere. Viewers supplied it. So did outrage. So did doubt. People watched it once, then again, slower. They paused at the moment the officer said obstructing, replayed the glance toward the camera, the half-second where authority seemed to choose itself. They listened to the attorney's tone calm, almost instructional, and argued about whether calm was enough. Comment sections hardened into camps. Some asked what wasn't shown. Others said nothing more needed to be. By morning, local reporters had verified the time and place. The timestamp matched the patrol log. The intersection was confirmed as a traditional public forum, under long-settled First Amendment doctrine. A constitutional law professor explained, carefully, that speech doesn't become obstruction because it's inconvenient. The clip climbed anyway, unburdened by nuance. Inside the department, the same video played on muted monitors. Administrators watched with legal pads open, note points filling margins. Training policy numbers were circled. Command presence, scene control. Officer safety. Someone wrote probable cause with a question mark that leaned like doubt. The supervisor's silence, so brief in real time, felt louder on replay. Silence is legible when you freeze it. A statement went out before noon. It was measured, sterile, almost soothing. The department took the matter seriously. An internal review was underway. Context would be provided. The words did their job, which was not to explain but to slow things down. On social media, they did the opposite. The attorney's name surfaced next, followed by his resume. Civil rights cases. Federal court. A record of wins that suggested the night hadn't chosen him by accident, or that it had chosen the wrong person. Viewers noticed how he never raised his voice, how he asked for a supervisor, how he cited the law as if reciting a rosary. For some, that restraint was proof of provocation, a man daring authority to contradict itself. For others, it was the point. Cable panels filled time with posture analysis. Was the officer aggressive? Was the attorney performative? The questions felt thin against the footage's density. What mattered was procedural, whether an order to disperse had been given, whether there was a lawful basis to detain, whether reading the law could be construed as interference. Lawyers answered cautiously. Commentators did not. The bystander who filmed it stopped checking their phone. Notifications stacked like weight. Messages ranged from gratitude to threat. They hadn't meant to start anything. They had meant to record. That distinction evaporates once a clip leaves your hands. By the second night, protests gathered not at the intersection but online. The footage had become portable outrage, a lesson you could carry. City council members requested briefings. Risk management asked for timelines. The mayor's office wanted to know how fast a lawsuit could land. Somewhere in the churn, a quieter thing happened. Officers in other precincts watched the clip in squad rooms before shift. A few scoffed. A few went still. One muttered, "That could be me." Another said nothing and adjusted his vest. The video kept moving, not because it was sensational, but because it was plain. No music, no cuts. Just a man reading the law and the law being answered with handcuffs. In the economy of attention, clarity is rare. It travels. By the time the attorney was released, the clip had crossed state lines and lost its local accent. It didn't need it anymore. It had become a test people could administer from anywhere. Press play, then ask what power owes restraint, and whether anyone remembers the answer when a camera's watching that paper. Change the temperature of the room. The complaint arrived in the clerk's office at 9:14 a.m., stamped and docketed before the coffee cooled. Federal court. Clean margins. Numbered paragraphs that moved like a metronome. The caption alone carried weight: an individual versus a city, a department, officers named and unnamed. The allegations were spare, almost austere. Retaliation for protected speech, unlawful detention, without probable cause, supervisory failure. Each count sat on precedent like a chair set squarely on the floor. By noon, the city attorney had it open on a second screen. The video paused mid-sentence while the law caught up in text. He read slowly, circling dates. The statute citations were not ambitious, they were obvious. That was the point. When the law is clear, ambiguity becomes liability. The attorney's filing did not editorialize. It reconstructed the night the way courts prefer: timestamps aligned to dispatch logs, commands transcribed verbatim from bodycam audio, obtained through a public records request. The pause before turnaround, the supervisor's line, "Do what you need to do," noted as an instruction without a basis. A training manual was attached at Exhibit C, its language suddenly animate. Command presence, it said, must be proportional. Proportional to what the complaint asked without asking. Extensions were requested and granted. They always are. Depositions followed, windowless rooms with water pitchers and clocks that ticked too loud. The arresting officer testified first. He spoke in short sentences, trained sentences. He described feeling concerned and uncertain, words that leave room for safety to enter. When asked to articulate the obstruction, he hesitated, then returned to posture and tone. The attorney across the table didn't interrupt. He waited. Silence, again, doing work. The supervisor's deposition took longer. He acknowledged hearing the statute being read. He acknowledged no order to disperse had been given. He acknowledged he had the authority to de-escalate and chose not to. The court reporter's keys clicked, faithful and indifferent. A municipal policy required supervisors to intervene when probable cause was unclear. The word unclear sat between them like a mirror. Body cam audio came last. The breath before commands, the radio crackle, the click of cuffs. Transcripts were prepared with forensic care. In one margin, a paralegal noted the exact second when the bystander's camera caught the glance toward it. Intent is hard to prove. Timing helps. Mediation was offered in a conference room that smelled faintly of carpet cleaner. The city came with a number that felt like an opening bid. The plaintiff declined without counter. He wasn't angry. He was precise. The law, he said, did not bargain well under pressure. It worked better in daylight. As discovery closed, the risk assessment memo circulated upstairs. It mentioned jury pools and pattern evidence. It mentioned training gaps. It mentioned the video's reach. The memo avoided the word wrong. It preferred exposure. The number emerged weeks later, not in a press release, but in a draft agreement. That passed hands quietly. $3.8 million. No admission of wrongdoing. Policy review promised. The figure looked like resolution on paper, and like something else in the pit of the stomach. A price is not the same as a reckoning, but it buys time. Sometimes time is what systems need to change their language. When the settlement became public, reactions split cleanly. Too much. Not enough. The attorney read the coverage once, then closed the tab. He knew what the money would do and what it wouldn't. It wouldn't give back the night. It wouldn't erase the click of steel. It would fund clinics, scholarships, work that would read the law to people who'd never been taught to trust it. In the quiet after the announcement, the case file thickened with signatures. Ink dried. The court moved on. But the video remained, pinned to the internet's corkboard, a footnote that refused to shrink. The lawsuit had done what lawsuits do best when they work at all. It translated a moment into consequences, not closure, consequences. And consequences, once named, have a way of asking what comes next. The memo came first, because memos always do. It arrived in inboxes just after roll call, subject line, clipped and careful. The kind that tries not to wake anyone up. Policy clarification and training update. Inside, the language was measured to the point of anesthesia. Supervisors were reminded of their duty to intervene when probable cause was unclear. Officers were instructed to distinguish inconvenience from obstruction. First Amendment encounters were to be slowed, documented, and, whenever possible, resolved without detention. The word retaliation did not appear. It didn't need to. Everyone knew why the memo existed. In the precinct, reactions split along predictable lines. A few officers read it twice, then folded the paper with an almost religious neatness. Others skimmed and scoffed. "So now we're lawyers," someone muttered. A sergeant cleared his throat and said nothing. Silence again, this time unsure of itself. Internal Affairs opened a file that would never quite close. Interviews were conducted with the softness reserved for colleagues. Timelines were compared. The supervisor's early retirement was announced without explanation, framed as a personal decision. The arresting officer was reassigned administrative at first, then back to patrol with conditions attached. Additional training, a note in the file, the kind of discipline that looks like movement if you don't stare too long. Outside the building, the city tried to sound like a city learning. Press conferences were held at podiums polished to reflect resolve. The mayor spoke of trust. The police chief spoke of professionalism. Neither mentioned the attorney's name. Names personalize things. Systems prefer abstractions. Changes did arrive, small and unglamorous. A revised arrest threshold circulated, citing case law that had always been there. Body cam review protocol expanded. Supervisors were required to narrate their decision-making on camera during First Amendment encounters. a procedural nudge toward accountability. At the academy, recruits watch the clip not as spectacle, but as curriculum. Freeze frame, discuss, repeat. Some leaned forward, some leaned back. The street noticed subtler shifts. Officers asked more questions before issuing commands. A few encounters stretched longer, not shorter. De-escalation takes time. Time costs patience. Patience is not evenly distributed. Still, fewer cuffs came out for voices alone. It wasn't reform, it was friction. Applied where momentum had once carried everything forward. The officer at the center of the footage learned how thin the line between anonymity and recognition can be. His name never treaded, but his face did. He stopped reading comments. His partner noticed the quiet and said nothing. At home, he replayed the night once, then didn't again. Memory edits itself when left alone. The attorney watched from a distance. He didn't attend the pressers. He didn't tweet. He read the policy updates the way he read statutes looking for verbs. Intervene, distinguish, resolve. He circled the words and filed them away. Language matters, he knew. It sets the ceiling of behavior. Months passed. The video's arc flattened, as all arcs do. Outrage found newer hosts. But inside the department, the clip remained a reference point, a shorthand. Don't make it another sidewalk, someone would say. The phrase did work. Not enough work. But some. Fallout is rarely an explosion. It's sediment. It settles into procedures, into habits, into the things people say when they think no one is recording. It makes scenes slower. It makes decisions heavier. Sometimes it makes them better. On the same block, the city replaced a cracked slab of concrete where the cruiser had parked. Fresh cement, cured under orange cones, smooth and pale. People stepped over it without noticing. The street kept moving, as streets do, but the ground remembers weight. The block looked ordinary again, which felt like an achievement and a lie. Morning traffic threaded the intersection with the patience of routine. A delivery truck idled where the cruiser once had, its engine humming a different kind of authority. The attorney walked the sidewalk without ceremony, jacket folded over his arm, phone tucked away. No cameras tracked him now. No lights broke the day into colors. He paused anyway, a habit he hadn't meant to keep, and let the moment pass through him without asking it for permission. The settlement money moved quietly, the way effective things often do. It seeded clinics that stayed open past 5. It paid for filing fees and bus fare, and the hours it takes to read a statute until it makes sense. Scholarships bore names that wouldn't trend. Impact rarely announces itself. Inside the department, the reforms aged into practice. Supervisors learned to narrate their thinking out loud, not for show, but because words slow hands. Recruits asked better questions. Veterans learned when to step back. Not always, not everywhere, but often enough to matter. A policy review committee published a report thick with footnotes and thin on drama. It concluded that clarity reduces conflict. The sentence read like common sense because it was. The officer kept working. He followed the new protocols with an attention that bordered on caution. On a later night, faced with a man speaking too much and moving too little, he chose conversation over command. The encounter ended without paperwork. He didn't tell anyone. He didn't need to. Change doesn't ask for applause. The video settled into syllabi and archives, a case study stripped of its comment sections. Students watched it without knowing the names at first. They were asked to identify the moment power could have chosen restraint. Many pointed to the same second. Some pointed to earlier ones. The exercise did its work. As for the attorney, he kept reading the law aloud, sometimes in courtrooms, sometimes on sidewalks when it mattered. He understood something more clearly now, that justice is not the feeling you get when you win. It's the exhaustion that follows insistence. It's the quiet knowledge that systems bend only when someone refuses to rush them. In the end, nothing dramatic closed the story. No siren. No verdict read into a microphone. Just a city a little more careful with its authority, and a man a little more resolved to test it in daylight. The Constitution did not change that year. The people interpreting it did, inch by inch. And on that sidewalk, where fresh concrete had long since darkened to match the rest, the law went back to doing its work, mostly unnoticed, occasionally spoken, always waiting for someone willing to read it out loud when it counts.